Good afternoon. My name's Michelle Maynard. I'll try to speak up. I have a pretty small voice, I know. I'm an elder law attorney. In 2023, I opened my own office in Topsom. That's where I'm from and where I live currently. Prior to that, I worked for small firms in Falmouth and Portland. Yes, go ahead. Practicing estate planning and elder law. And before that, I spent nearly 10 years at Legal Services for Maine elders in Augusta, Maine on their legal helpline. So today I'm going to talk a little bit about basic estate planning documents and what happens when people become impaired and they don't have those documents. And we'll touch a little bit on Maine care eligibility if long-term care does become necessary. I am a rarity. I'm an attorney that does not like the sound of their own voice. So please ask questions. I'd much rather have this be a conversation than just a presentation by me. So I wanted to start with financial powers of attorney. And I just wanted to ask, how many people here have a financial power of attorney document? Okay, very good. That's actually quite impressive. Hopefully all those documents were drafted by an attorney and they weren't done using an online form. That's a big mistake that I see often. Sometimes those forms do not comply with Maine law, so they're not worth the paper that they were, printed on. But a financial power of attorney can be extremely important if you do become impaired in the future, because contrary to what many people think, your spouse does not have legal authority to act on your behalf regarding financial matters. You actually have to appoint someone to be your agent to do that. So I'll just talk a little bit about the terminology because this is a pet peeve of mine. The power of attorney is the document itself. Okay, the person who signs a power of attorney is called the principal. And the person who has authority to act for the principal is now called an agent. Years ago, they used to be called an attorney in fact, but that was a confusing term to use. So the financial power of attorney is a document that's in effect during your lifetime. And it can be effective when you sign it, or it can be what's called springing, which means it doesn't take effect until a stated condition in the document happens. And usually that's a determination by a doctor that you're incapacitated or a judge that you're incapacitated. Okay, so you can have a primary agent and successor agents, or you can have co-agents who have equal authority to act. And oftentimes having co-agents is a good idea if they get along well with each other. And that's very important. And you have to pick the right people to be your agent, because in the wrong hands, a financial power of attorney is a license to steal. And unfortunately, I saw that side of things pretty frequently when I worked for Legal Services for Maine elders. So what I tell my clients is that you pick not the people that you love to be your agents, but the people that you go into business with. So the people that you have no problem handing your checkbook over to now, or all your online passwords for your banking, because you trust them implicitly. Because there's no real oversight for an agent. So they can have a lot of authority and no one's looking over their shoulder to make sure that they're using your money and property for your best interest. An agent is a fiduciary, which means they do owe you a duty of loyalty. They always have to act in your best interest, and they're held to a very high standard of good faith and fair dealing, acting regarding your assets. But things need to get pretty bad for law enforcement to get involved with that. And prosecuting financial exploitation by an agent is very difficult, and there's almost zero recovery of stolen assets. So you have to pick the right people for sure. With a financial power of attorney, usually agents are given broad authority to handle your financial affairs. That can be anything from paying your bills to, filing income tax returns for you, dealing with real estate, making withdrawals from retirement accounts, basically anything that you can do for yourself, except sign a will. Your agent cannot do that for you. But anything else your agent can do. You can also give them a couple of extraordinary powers, such as gifting. And gifting becomes important if long-term care is ever necessary and you want to protect assets for your spouse at home or even your children or grandchildren. Okay, are there any questions so far about a financial power of attorney? No? Okay. So if someone does become impaired and they don't have this document, then a loved one has to petition the county probate court to become appointed their conservator. And this is sort of a last resort thing. You don't want to do this unless it's absolutely necessary. It used to be that petitions for guardianship and conservatorship were rubber stamped by probate judges. And then there was a big movement among the disabled community to change that. And they did change the law in 2019. And now it's quite difficult to obtain guardianship and conservatorship over someone. You have a very high burden to meet to prove incapacity. So it can be a contentious proceeding if the respondent, the alleged incapacitated person, objects to any part of the petition, and a judge would appoint them legal counsel to represent their interest. If they have any resources, they'll pay for that attorney out of their own resources. But it can take months to obtain an order. It's expensive. And the court stays involved even after they do appoint a conservator. So the conservator has to file annual reports and annual accountings that a judge will approve. So it is more burdensome for your family to become conservator for you than if you had named them as agent in a financial power of attorney. So I tell people, don't put yourself and your family through that. It's not fun. The respondent does have to appear in court for a hearing, and a judge who has never met you will make that decision for you. Yep.
When in a relationship, if I have my husband's power of attorney, when can I put that into effect? How does that go into effect?
It depends on what the document says. So if he made it effective when he signed it, as agent, you can start acting for him immediately. When he has capacity, you have to act according to his direction. So he's still in charge, but he can authorize you to act for him. If it's springing, there's a stated condition in the document that must take effect before the document. Many different names. In Maine, we tend to use Healthcare Advance Directive, and that's really two parts. One is that healthcare power of attorney, where you name an agent who can make medical decisions for you. And the second part is what we used to call a living will, where you can leave those end-of-life healthcare instructions, your preferences regarding organ donation, and your final arrangements and things like that. In other states, it's called healthcare proxy. Again, it goes by many, many names. This document can also take effect immediately when you sign it. And what that means is that your agent can have access to your medical records and be able to speak to your medical providers. It doesn't mean that they could automatically start making your healthcare decisions for you. Your doctors by law are supposed to always look to you first to see if you can make an informed decision about your treatment. Okay? The other reason that it's a good idea to have a healthcare advance directive, other than just making sure that your wishes are enforced, is that if you do need to go to a long-term care facility, some facilities will not admit you as a resident without having an agent under a healthcare advance directive who can sign the admission contract for you. Okay, so directive. If you don't have one and you became incapacitated, then most likely a family member is petitioning the probate court for guardianship. So conservatorship has to do with your assets and your property. Guardianship has to do with your person. So medical treatment, where you reside, who has access to you, who can visit you, and things like that. And again, going to court is expensive, it's time consuming, and the court does oversee that guardian. They have to file annual reports, and they have to ask the court's permission to do certain things, such as move your primary residence and other things like that. So you might have to go to court several times throughout the incapacitated person's lifetime. Okay? any questions about guardianship or advanced healthcare directives?
Yeah, there's an acronym that's been thrown around, POLST. How does that relate to this?
Yes. So those are physician orders, and they go into a lot more detail than advanced directive. There's several different forms you can have. There's a 5 wishes form, there's the pulsed form, and again, it's just a lot more detailed about what treatments you do or do not want. So if it's important to you to make your wishes known, you might want to look at an additional document besides just a healthcare advance directive.
And so, with the POA, you were saying that it's very important to have that drawn up or stamped in by an attorney. How about the advance directive? I mean,
Not as important to have
Yeah.
an attorney draw that up. Maine Hospital Association has an advanced healthcare directive that is widely used, and that form is acceptable.
it's just, okay.
Yeah, so this is the only time that I will say you can use an
Right.
online form, and that is legal and it's quite sufficient, so.
So
Michelle?
those are easily updated.
Yes, that was my question.
Are they easily updated?
Yes.
Yes. So as long as you are sound mind, you can revoke and amend both a financial power of attorney and a healthcare advance directive. For a financial power of attorney, if you want to make changes, I would just recommend, signing a new document. But you can make manual changes to your healthcare advance directive. Sign it, the change, date it, and that would be recognized.
Yeah.
So easily done for the healthcare advance directive. Jim?
That was my question, but this young lady had a question here.
Actually, it's not a question. I work at Midcoast Hospital and they offer that form for advanced directives.
Yeah.
You can just fill it out, give it to the person at registration. We scan it right into your account as well as posts. But it's free. You don't even have to print it out, so.
Yeah.
Just wanted to add that.
Yeah, that's great. They are widely available
Yeah.
in most doctors' offices and hospitals. And again, that's the only form that I think is fine to use. And it does need to be signed by 2 witnesses. If you basically stay in Maine, you don't even have to have the advanced healthcare directive notarized. If you do travel out of state, it is wise to have it notarized. Okay, anything else? Okay, then I'll just move on to basic estate planning documents. So in Maine, you really have a choice. So you can have a traditional will that only takes effect upon your death, or you can have revocable living trust. And in some states where probate is a nightmare and it takes years and is very expensive, everybody has a living trust. And they can't imagine not having that. But in Maine, probate for the most part is not terrible. If you have an original will and there's no contest as to who the personal representative should be or the distribution plan in the will, you can do what's called informal probate. And the named personal representative in the will files some paperwork with the probate court. Depending on the county, will depend on how long it takes to get them appointed. I know up in Piscataquis County, you can get appointed the same day. In Cumberland County, it can take 1 to 2 months. So it just depends on the county. But the judge of probate is never involved. There's no court hearing. So it's simply an administrative process. And probate still takes 9 to 12 months typically, but a lot of that is inactive time where not much is happening. There's a 4-month creditor period where you can liquidate assets if you're the personal representative. You're just not going to distribute assets out of the estate. But it's not a terrible process. The probate filing fees and legal fees run, a couple $1,000s perhaps. Again, if there's no contest, and it's a pretty straightforward estate. A living will is a little different. It's typically used to avoid probate. And what it is it's your alter ego. So it's a trust that you create. You are the trustee, the manager of the trust, and you are the lifetime beneficiary of the trust. So it's all about you. you have full control over the assets in the trust. And the trust uses your own social security number. So it really is, you know, your alter ego. And to make a living trust work and be effective, you have to properly fund the trust during your lifetime. So you transfer title of your assets, including your home, into the trust, and the trust owns the assets. And that way, when you pass, there should be nothing that goes to your estate, and then probate's not necessary, okay? So the trust is a little bit more expensive to set up. The trust is a more complicated document than a will, and you have to actually go through the work of transferring assets into the name of the trust. So I tell people that with the will, more of the expense and the work is done after you pass. And with the trust, more of the expense and the work is incurred on the front end when you create it. But both are valid options in Maine. And I don't pressure people to do a trust. Like, again, other states, it's just, there's no other option. You have to have the trust, okay? So again, with the will and a trust, you can amend it, you can revoke it as long as you are of sound mind. Again, the will doesn't take effect until your death. So you have plenty of opportunity, hopefully, to make changes if that's what you want. You can also do a codicil, which is an amendment to a will. So if you just want to make one small change and you don't mind the world seeing what your original will said, then you can simply do a codicil. And that's a pretty cost-effective way to make a simple change. Another reason some people prefer a trust is that wills are public once a probate has started. So anyone can go to mainprobate.net and look up someone's will if their estate has been probated. For most people, that's not so important. You know, if they say, I leave everything to my spouse, and then when both of us are gone, everything to my kids, you know, most people don't care if the world knows that. But if there's something sensitive in your will, if you disinherit a child, or you really let someone know exactly what you think of them, and you don't want the world to know that, then a trust would be the way to go for that. And keep it private. Only the trust beneficiaries are entitled to a copy of the document. Okay. Any questions on this? On wills versus trust? This is probably the most common type of question I get. Yes.
Can you add to the trust, like if I started a trust for my 5-year-old, could I?
Well, that's different.
Oh, okay.
That's, you can have a trust in the living trust for minor children or a disabled person. So it can contain sub-trust.
Okay.
And yes, you could add to that. If you had a standalone trust for your child or a disabled person, that's different, and you could fund that at any time.
Okay.
Yeah.
Thank you.
But you can add assets to your living trust as long as you're alive. So, yep.
So I assume that the person who is establishing the living trust, the individual, needs to be, needs to have capacity, is your phrase,
Yes.
jargon. So a person with power of attorney can't do that for someone. It has to be the individual.
Well, that's not
Okay,
correct.
yeah,
Yeah, so your agent under a financial power of attorney,
okay, can do that.
if the document allows it, can create
Gotcha.
trusts for your
Okay.
benefit and the
Gotcha.
benefit of your family members.
Okay.
Yeah.
Thank you.
Does Maine have the, oops, I forgot, basically a rollover trust? So you fund everything and then, oops, I forgot this?
Yes, so even if you have a living trust, you also have a pour-over will.
Mhm.
And that is in case you forgot to put an asset into the living trust during your lifetime. And the will just references, hey, I created this trust, I want everything to go into the trust, and that's where this asset will go. So there is a just in case document. So you still have a will with a living trust, but it doesn't contain your actual estate plan. Okay.
As your, for instance, if your spouse ages out, you know, or needs care, and your property, as the money runs out, is your property protected?
if it's in a living
So that the living
trust.
spouse can continue to stay and live in the property.
Yes. So a living trust does not offer any asset protection from long-term care costs. It is a probate avoidance tool, okay? So there's other types of trusts that are used to try to protect assets. And usually those are irrevocable, so you can't change those. So once you've transferred assets into that type of trust, it's done. And the point is, you go beyond 5 years after you've transferred assets into that type of trust before you or your spouse needs to apply for main care, for nursing home or residential care. So those are a very different type of trust. A living trust is not going to offer any asset protection because you still have full control over the assets. You haven't given up anything by putting it into the living trust, so that's why there's no protection afforded there.
Can you not do that by putting houses in joint tenancy?
Well, joint tenancy is, a form of ownership where there's an automatic right of survivorship. So this is how most married couples in Maine own their primary residence. And it makes sense because generally you don't want to have to probate the first spouse to die's estate. And usually it's the real estate that necessitates probate, not always, but it just depends. But if the surviving spouse needs long-term care, then they're the sole owner of that real estate, and they can qualify for main care while still owning it. However, if they go into a nursing home and receive nursing home benefits for main care, there'll be an estate recovery claim after they pass. So when you get on main care for nursing home benefits, the state of Maine wants to be reimbursed for that. And they wait until you pass. They don't put a lien on the property during your lifetime. But if you own the property at your death and you don't have a surviving spouse, a disabled child, or a minor child, then the state of Maine can force your estate to sell that property and pay their claim. So, joint tenancy can prevent an estate recovery claim if the other joint tenant is alive. So that's a caveat. But if it's a married couple and the surviving spouse needs care, then that property is vulnerable to estate recovery.
Is there a way around that?
Well, yes, we'll jump into main care eligibility. So the big thing with main care eligibility is both there's an asset limit and there's the 5-year look back period. So the asset limit for the spouse applying or the person applying is $10,000 of countable assets. And your primary residence is not a countable asset for eligibility purposes, but everything else is countable pretty much. Retirement accounts, cash, investments, stocks, bonds, second pieces of real estate, unless they're income producing, are all countable. So you really have to become impoverished to qualify for main care. So people like to give away their assets to avoid having no money at their disposal or no money for their family. But there's this 5-year look back period. So when you apply for this type of main care, the Department of Health and Human Services, when they review the application, they look through all of your financial records for the previous 5 years. And they're looking to see that you disclosed all of your assets, you didn't omit anything. And 2, have you given anything away in the last 5 years? And if you've given something to someone besides your spouse, a disabled child, or a trust for a disabled person, you'll be penalized on that gift. So the more you gave away, the longer there's a penalty period where you don't qualify for main care and you have to be paying privately. So to give away assets, you have to be very careful about it. You have to realize that you need to get beyond 5 years. And right now, the look back period is 5 years. For a very long time, it was 3 years and it was increased to 5 years. I would not be surprised in the future if it's increased to 7, because our population continues to age and more people are needing to go into long-term care and it's so expensive. So you just have to retain sufficient assets in your name to be able to privately pay for 5 years. So it's risky to transfer assets. And there are some ways that it can be done, but it's probably beyond the scope of this talk today. But I want to just mention that adding someone's name to your deed, to real estate, if you add them as a joint tenant, and you do that within 5 years of applying for Maine Care, you are gonna be penalized, and what they will do is they will look at the fair market value of the property, and what, I should say your equity in the property, when you made that transfer, and the full amount of the equity is considered the gift. So it's not even half. So if your home is worth $400,000 when you added a child tenant to your deed, you are going to be considered having gifted $400,000 to that child, and you will be ineligible for Maine Care for several years. So you have to be extremely careful about gifting. So Maine Care eligibility, it sounds really scary, but there are some things that you can do. So again, spouses can gift to each other without penalty. So that's why it's important to have a really good financial power of attorney that was drafted by a Maine attorney that permits your agent to make gifts to your spouse. Because if you have a spouse living at home, it'd be nice if they could have more resources available to them. And that's one way to do it, is through their agent under their financial power of attorney, okay? And again, if you have a disabled child, you can also make a gift to that child or create a trust for their benefit and fund that trust. But again, you should consult with an attorney before you do anything, like that. So for nursing home Maine Care, the community spouse, the spouse living at home, is also subject to an asset limit. And currently that's $159,000. But there are legal, loopholes that you can utilize to increase that amount that goes to the healthier spouse living at home. For residential care or assisted living Maine Care, the community spouse is not subject to any asset limit at all. So they can be a millionaire and their spouse can qualify for Maine Care.
I'm sorry, can you repeat that last?
Yeah,
Oh, yeah, that's the difference between
nursing home and residential care.
Residential.
Yeah. So again, for residential care, the community spouse can have unlimited assets.
Can you
Define
residential care? Yeah.
Assisted living,
Okay,
yeah.
but you have, okay.
Yeah, under the Maine Care terminology, it's referred to as residential care. Most people will call it assisted living.
Okay.
Yeah. Go ahead.
So an Alzheimer's care facility is which?
It depends. So memory care is confusing because it could either be licensed as a nursing home or it could be licensed as residential care.
That's how it's licensed.
It depends how it's licensed, correct? Yeah.
But that would affect, I would assume perhaps a residential care person might say, no, I'm sorry, your spouse needs to be in a nursing home, not in.
Well, there's a medical
Residential
assessment
care,
that's done.
yeah.
So there's a company called Maximus.
Yeah.
It's a funny name.
Yeah,
And they have the contract with the state of Maine
right.
to do the medical assessments for long-term care. So they determine what level of
What,
care
yeah,
someone
gotcha.
needs, either residential or nursing home care. And there's a third Maine Care long-term care program called the Waiver Program. And it's for people who are medically eligible to be in a nursing home, but they want to stay at home and receive in-home care. And the Waiver Program can provide limited assistance for that. Usually the hours are not enough to safely keep someone at home, so you have to either be able to supplement that, privately, or it's perhaps for a short-term basis.
Yeah.
Okay. So the thing with Maine Care eligibility is that it also, you have to factor in what level of care is needed because that can determine how quickly you can apply for Maine Care. So all nursing homes in Maine accept Maine Care.
They are not legally allowed to discriminate between someone who can be privately paying and someone who has to apply for main care relatively quickly. I will tell you, it happens all the time. If you can tell them, oh, we can privately pay a few months, a bed suddenly opens up, where it hadn't before. So it does happen, but legally, they're not allowed to do that. Residential care facilities don't have to accept main care, and some nice ones don't. They're strictly private pay. And when you run out of money, you have to move. More often around here is that a residential care facility may require a private pay commitment, and that could be anywhere from 6 months to 3 years. And that's something that you negotiate directly with the facility. And it simply depends on supply and demand. The longer their wait list is, the longer they can ask for a private pay commitment. And so after you've satisfied that private pay commitment, then the resident may apply for main care. So an Avita is a good example of that in Brunswick. You know, they usually request 2 to 3 years of private pay. Okay, so having more money can get you better care and more options, particularly for residential care. Okay.
How does the long-term care insurance fit into all of that?
Yeah. So if you are lucky enough to have long-term care insurance and you can still afford the premiums and you have a good policy that you purchased a very long time ago, usually it covers all levels of care, okay? And the facility will need to probably provide some medical documentation to support your claim for benefits. But those benefits are paid out to the agent for the resident. And you can still get on main care if you have a long-term care insurance policy, or you could be private pay. It will reduce the amount. And there's a few policies that are called partnership policies. You have that, that's excellent. Where basically the amount that has been paid out under the policy increases your asset limit. So it can be a wonderful thing to have. But those are rare, so that was
They're expensive.
and very expensive, yes. So most people do not have long-term care insurance. Right now, it's almost impossible to purchase a policy. It's so expensive. The insurance companies just wildly underestimated how many people would be making claims on these policies decades ago. And so it's quite rare to have long-term care insurance. So most people in a long-term care facility are on main care. It's about 80% of residents in many long-term care facilities are on main care because it is so expensive. Any other questions about main care? I mean, we could talk about main care all evening. I would say what's really important is if you or a loved one receives a diagnosis, which makes long-term care much more likely in your future. If you get a diagnosis of Parkinson's or dementia, you and your spouse or you and your family need to consult with an elder law attorney to figure out what you need for documents and what could potentially be done to protect some assets, if that's important to you. People have different philosophies about asset protection for long-term care, and I think both are valid. Some people feel like if I have the money, I should pay my own way. That's only right. It shouldn't be put on the taxpayers. Other people feel I worked really hard. I want what I saved to go to my family. I don't judge. I think both are valid opinions, but if protecting assets is important to you, you need to get planning, and you need to see an attorney who not only does some basic estate planning, but is a true elder law attorney. Because I've seen so many financial powers of attorney that were done by, an attorney who is a generalist, and they don't allow gifting, even to the spouse. That's not really helpful if one spouse needs long-term care. So you really need to talk to someone who knows the main care rules, who does main care applications, instead of just seeing an attorney who does a little bit of everything. I don't know how attorneys can do that anymore. Things are too specialized, and so just talk to an attorney as soon as you can. Don't wait 2 or 3 years after receiving that type of diagnosis before getting legal advice. Okay.
Is DHS, are they absolutely rigid about long-term care and the criteria?
For the most part, yes. It does depend on which caseworker is reviewing the application. So there's always that human element to things. If you have an experienced caseworker, they may let some smaller things go, because they can probably see that the applicant's intent wasn't to try to circumvent the rules or impoverish themselves to qualify for the program. What I'm finding now is that many of the caseworkers are more inexperienced. They came from community main care, which is very different, has very different rules. And half the time they answer the general telephone line, and half the time they're reviewing these long-term care applications. So it's not great right now, I have to say. Even just a few years ago, there was a pool of much more experienced caseworkers. And again, they knew sort of what to look for in terms of red flags, and would let minor things go a little bit more easily. With an inexperienced caseworker, they're turning to their supervisor for everything. And so I'm not finding that there's as much, leniency regarding some minor things. Yeah.
Hi, I'm the power of attorney for a friend who's in subsidized housing. She's got dementia. She has nothing. She's Section 8, but she has some antiques, incredible jewelry that's stuck in the safe, and stuff like that. If she's on main care, and if I have to put her in a facility, does the state come in and start rooting around? Are they gonna take, Uncle Tony's portrait and?
No.
Okay.
Unless the tangible personal property is quite valuable,
Some of it is.
DHS doesn't really care.
Okay.
And they definitely do not come in and inspect anything. It would be up to you to disclose something on the application. And so you just need to be careful about that, because if you fail to disclose something, that could be fraud against a governmental agency. So what I tell clients when I do represent them for a main care application is I do not lie to DHS.
Right.
My reputation as an attorney is much more important to me than you gaining 1 month of eligibility for long-term care. So everything is fully disclosed, even if we manipulate the assets a lot and we purchase, let's say, a Medicaid compliant annuity, and we do lots of things to accelerate eligibility, it is fully disclosed to DHS and everything is transparent. I would not represent someone who insisted upon, lying on an application. Yeah. So I would, at the time, get legal advice about what to do as agent for this person. But for the most part, DHS would care about, vehicles, snowmobiles, boats, things that have some substantial value to them. Household furnishings, they don't want to get involved in things like that.
Family jewelry.
Again, it would have to be, really have a worth, a net worth to it, not, something that's just a couple $100 or something.
No, this is, okay.
So, sort of everything is a case by case, but generally, a caseworker is not interested in personal effects, household furnishings. It's the larger items of tangible personal property. So.
Thank you.
Yeah.
There's also, I just have gone through the jewelry end of things, for my parents, or, jewelry that they had, the value is usually a whole lot less than
What they think it is.
what they think it
Yes.
is and what they paid for it, and it's a lot less. So that's just a point,
Yeah.
Because we thought we had diamonds worth, you know, a ton of money, you know, but they just aren't. Yeah, oh well.
Any other questions about main care?
What is a Medicaid compliant annuity?
Okay. So a Medicaid compliant annuity is a very specific type of an annuity that you would use if someone is applying for nursing home main care and they have a spouse that is subject to an asset limit. So again, the spouse can have $159,000 of countable assets. And so what you can do to sort of increase the amount that can go to the community spouse is purchase this annuity, which converts excess assets into an income stream for that community spouse. So it's not an annuity that you use as an investment product. It's not meant to, you know, generate a good rate of return for you. It is simply meant to accelerate Medicaid eligibility. And it is legal, and the spouse has to have the annuity for at least a year. So their health is really important in figuring out whether or not this is a good option. Because if they die during the term of the annuity, then the state of Maine can take what's left for those main care benefits. So it's something that is something that just has to be analyzed to see if it is a good option for that community spouse. And the reason that this works, I should clarify this, is that for nursing home eligibility, the community spouse's assets only matter for the month of application. So the main care recipient always has to be under $10,000 after they're on main care. But for the community spouse, DHS only cares about their assets the month that that application is submitted. So it's like they take a snapshot, and for that month, they need to be under the $159,000 limit. The following month, the community spouse could win the lottery, and that's okay, as long as they keep the assets in their name and they don't commingle them with the main care applicant's assets. So this annuity starts making monthly payments to the community spouse, and sometimes they're quite large payments. You know, it's $5,000, $10,000 a month coming back to the community spouse, and that's okay because their spouse is already on main care, and now their assets are no longer relevant. Yeah, and it's something that you do immediately before submitting the main care application or as part of the main care application. It's not a type of annuity that you purchase in advance. So again, if you're concerned about protecting assets, you talk to an elder law attorney and they can help you through that main care application.
And that's the only relationship is spousal where this applies, or?
I mean, I have purchased those annuities for a single person as part of a gifting strategy. So their agent made a gift for them. They're facing now a penalty period, and as a way to make sure they have sufficient assets to pay privately through that penalty period, we purchase an annuity for them, and they have more income coming in. But most of the time, it's for a married couple. Good, okay. There's no other questions. I'll wrap it up. Okay. Thank you.
Thank you.